How's it going, everyone? This is Chapter 6, Medical Law and Ethics. We're going to talk a little bit about this from the perspective of the Cengage textbook. So if you have any questions, don't hesitate to reach out, but we're going to run through this real quick, and I hope you get a lot out of it. Make sure you read the text right. That's the most important part. The majority of the information is going to be in the text, and this is just a broad overview. The overview, of course, is only going to be about 15 minutes. I do have the textbook with me, and I'm open to Chapter 6 right now, so we're going to be able to follow along together, and I recommend that you have your textbook open when you take a look at this lecture as well. So, Chapter 6 starts on page 135, and we're going to go through a few things really quick. There's course objectives. You can read through this. Of course, this is uploaded in the module, but there's going to be some different information in here related to what we need to learn in this course. But moving on to practicing medicine. Of course, practicing medicine is extremely challenging. You have to have a lot of training, and there's a lot of risk that comes with it. So that's when we talk about medical malpractice and negligence quite extensively in this chapter, because there are risks for patients. And if we don't treat patients with the care that they need, then negative outcomes can happen. So when we talk about statutory guidelines, each state is going to have different guidelines by which they allow medicine to be practiced in their region. So those guidelines are what entities have to follow based on the state they're in. I can give you examples of this, of how I did my example here, because the last example didn't make much sense. But medical assistants. Some states require medical assistants to be certified or registered. Other states don't, like the state of Alaska. So the state of Alaska, you can pretty much train anyone to be a medical assistant as long as they're practicing under the provider's license. So there's some differences state by state. So practicing medicine can be dependent upon where you're at in the location. There are federal guidelines as well, statutory guidelines that kind of develop standards. So HIPAA is another guideline we all have to follow. So there's difference between state and federal guidelines. We're not going to talk about that extensively right now, but I want you to be aware of the difference. When we talk about negligence and malpractice, negligence is, of course, failing to do something that a reasonable or prudent person would do. So when we're comparing this in the medical field to a provider who has training in oncology, maybe an oncologist does something that someone that's been an oncologist for many years wouldn't do. So a new grad makes a mistake. Or it could be some innovative type of medicine that has an adverse reaction on a patient. There are risks and benefits to healthcare, but acting in a negligent way can, of course, get you into a malpractice situation. So, those are just a few examples. We see a lot of malpractice cases, especially in OBGYN care, and delivery can be challenging, and there can be adverse outcomes. So, a lot of times providers on the OBGYN side of things are the recipients of malpractice lawsuits. I have met a few people who haven't had a lawsuit, but that is rare. But malpractice lawsuits alleges misconduct of the professional and implies greater duty of care to the injured person. What has to be there for malpractice lawsuit to really hold firm? These are really great points here that everyone should be aware of. There has to be a relationship, of course, between the provider and the patient. The relationship has to be established on duty owed by the healthcare provider to the patient. The duty to the patient had not been upheld by the provider, so the provider didn't do something that they were supposed to do, or they made a mistake. The healthcare provider breached the duty that they, of course, were supposed to give to the patient. That's the mistake that we're talking about. The patient had an issue or injury due to that mistake. And finally, the healthcare provider's breach was proximate cause to the provider's injury. So what that means is, due to the mistake that the provider made, it's a direct impact to the patient. So proximate cause occurs when the healthcare provider breach was a direct result of the patient's injury. So the mistake the provider made is the reason the patient had an adverse outcome. Because there could be other issues involved, right? Maybe a patient didn't follow the guidelines that the general surgeon suggested or required, actually, let me use a different one. Maybe the general surgeon required a patient to not eat 24 hours prior to surgery, and the patient ate anyway, and there was an adverse reaction because of that. And that would be a blip in the medical malpractice lawsuit. So, they would be able to point that out, and of course, more than likely, the case wouldn't hold up in court. All right, let's not worry about the knowledge check, but you can take a look at that yourself if you're interested. All right. What is duty? So duty is the patient-provider relationship, which establishes, of course, duty of the healthcare provider to the patient when it can be demonstrated that the patient consulted the healthcare provider from medical office and the elements of the contract were met, including offer acceptance and mutual agreement. So we get to duty by a contract. And you might think of this as a contract, like when you sign a contract to buy a house or sign a contract to buy a car. It's similar. When a provider sees a patient comes in, there is an offer to accept care, and we'll talk primary care just as an example. So when a patient comes into a primary care provider, there, of course, is an offer from that provider to take on their care, the patient's care. The patient has to accept that offer, and there has to be mutual agreement and mutual understanding that there's a provider-patient relationship. So each profession and society has a different expectation to establish this duty. And I just gave you an example of healthcare. But breach of duty by the healthcare provider or by action or inaction is measured against the standard of care. Another example. A patient had lab work done ordered by a primary care provider, and there were some negative results in there, but the primary care doc didn't see it and didn't look over it within a 1-month time period. By the end of the month, the patient had a really bad case or a disease, and it couldn't be treated. But it could have been treated prior if it would have been caught, maybe a week into the lab work. That would be a standard of care challenge for the primary care provider, because the standard for most organizations is within 3 days, and some have different, and some say 7 days, but I would say the average is 3 days. So, of course, that would be a negligence issue. And it might not be just the provider, maybe it's the healthcare organization as well. And we're going to talk about, hopefully in the future, pretty soon, is respondeat superior, which is a Latin term on the legal side of things, which means let the master answer. And what that means, and of course you probably already read this, but it means that the healthcare organization employing the provider is also at fault for that issue, because maybe it's not the provider's fault. Maybe the MA or the RN didn't get the information over to the provider in time. So there could be a lot of different scenarios that are at play here when we talk about medical malpractice. So we talked about the standard of care. You have to meet a certain standard that another prudent person would meet. And when we say prudent person, if we're talking about a provider, another prudent provider, right? So injury, of course, to sue in malpractice, the patient has to have an injury, there has to be an issue, and there has to be causation. But for causation or proximate cause, and we talked about proximate cause as in addition to but for, so that's what is needed. There has to be proximate cause from the perspective of due to the provider's issue that they had, the mistake they made, there was an injury to the patient, and we've given examples of that. Talked about informed consent. It's a process of communication, usually written communication, in which a patient agrees and consents to the treatment that the provider is going to give. This is how a provider can potentially give breakthrough medicine to a patient with the understanding there could be an adverse outcome. So a patient has to have that understanding through informed consent, and informed consent has to be in place for treatment to take place so the provider protects himself from legal issues. So there is informed consent from the perspective of the emergency room that can be a little bit different. Say a patient comes into the emergency room and they're not able to provide consent, and they don't have a power of attorney with them. In that situation, the provider would be protected under the, I had to pause for a minute to remember the name, but it's a Good Samaritan law. So it's the provider doing what they can under EMTALA and the Good Samaritan law to protect the patient, to do what they can and to treat them without their consent because they're acting in the best interest of the patient at that given time, even though the patient might not have wanted it. However, a patient can have a do not resuscitate, maybe a lanyard or a wristband or something in their chart, and the provider would have to follow that. So we talked about healthcare providers and informed consent. There's a little bit of information there that you need to be aware of. Make sure you read that in the chapter. All right, we're not going to go into the knowledge yet. Impact and defense. Impact is a medical malpractice suit that's traumatic for the healthcare provider involved. The negative emotions of a healthcare provider who has been sued may fester long after the litigation, and it might impact their relationships with future patients or colleagues, especially depending on how complex it is. Healthcare providers concerned that they may be sued for malpractice may order every known test in search of a definite diagnosis. So that's a way they have a defense, right? That's what they can do to protect themselves. And it's not always something that's a good thing because it can be very costly to the patient. And it also depends on what kind of medicine they're performing, right? The provider may avoid seeing more complex patients due to this litigation or concern of litigation. You hear providers say about things about medical legal all the time. So we have providers that are worried about this, and it depends on their specialty. But as a healthcare administrator, you have to be able to bridge that gap and let them know that mistakes will be helped from the perspective of the organization they work for. A lot of it depends on where they work and what kind of protections they have from that environment. We're not going to talk a lot about negative defense and economics of medical malpractice, but there are economics, right? It can impact the practice in a negative way financially. We're not going to talk about these two things, but important to read, the effect of prescriptions. There are a lot of serious illnesses that come out of prescribed medication, especially when we're talking about narcotics in the past. And I assume that quite a bit of you are going to do your paper on something similar to this. Risk management is something that's used on the healthcare side of things. There are risk management departments that help organizations make sure that they have the right setup. So when a patient walks in the door, you have to do A, B, C, and D in order to have a definite diagnosis and treat the patients in a way that is least risky for the providers. And that happens quite often. So there are risk management departments, and they help you through these challenges of potential malpractice and potential quality issues for patients. So that's for patients' benefit. Lack of empathy, I think you can read into that and know what that means from the perspective of malpractice, but we have to be careful not to have that impact our quality of care. All right, we talked about defenses. There are defenses, statute of limitations, right? That's when there's a limitation to when you can bring up an issue. And quite honestly, this is run into quite a bit. Maybe 10, 15 years ago, something happened and a patient wants to sue a provider, but maybe the statute of limitations has already passed and they're not able to do that. So that protects the provider. And there are other items here that can be important to review. So we're not going to talk about the statute of limitations, but read over that. It's really helpful. And it's in play quite often in the society today. Contributory negligence is conducted between standard of care when he or she is legally required to conform to his or her own protection. Patient does not do anything to contribute to their suffering and has behavior. We talked about this. So the behavior contributed to the negligence of the provider. So the example I gave you about the general surgeon and not eating 24 hours would be a patient contributing to this negligence and would protect the provider. Assumption of risk, we've talked about a little bit from the perspective of complex and known danger. Maybe that informed consent said there are risks involved in this care. Be sure to read over this, but that would also protect the provider because they're just doing something that they've already talked to the patient about. All right, we're not going to go over the knowledge check. In an emergency, we talked about the Good Samaritan law. There's some information here that you need to read, and I think it's important to have that taken care of from that perspective. Not going to really highlight product liability either. And there are a few more slides I think that are interesting for you to read, but not something that you're going to find in tests. And I want to keep this lecture under 15 minutes. Hope you enjoyed Chapter 6. More information to come there are some key considerations here. Make sure you read the chapter especially.